You're out of your mind.
That's my understanding, Your Honor.
Ms. Sullivan, tell me I'm out of my mind.
Adam Vernon on behalf of the department.
Donna Hansel, on behalf of the minor children.
Good afternoon, Your Honor. Elliot Blumberg on behalf of Timothy Lee, the non-respondent parent.
May it please the court, Your Honor, my name is Sonia Cannon and I represent the mother, Renora Lee, and I have a co-counsel as well.
Sure.
My name is Craig W. Wellhart. I represent Ms. Lee as well.
Thank you. Nice to see you again, Mr. Wellhart.
Good seeing you, Your Honor.
All right. We have a a bench trial set for.
It's a jury trial.
Is it a jury trial?
Yes, it
All right.
is.
Jury trial next week, as I understand it. And we're in the circuit court because we don't have enough room for all of the attorneys here. Yeah, starting the 22nd,
22nd.
Wednesday of next week, Wednesday, Thursday, and Friday. And there are a number of motions that have recently been filed on behalf of the mother. Has Mr. Vernon, if you received copies of those?
I received the motion, yes.
Mr. Blumberg, have you received copies?
Believe I have. I thought Mr. Vernon had also filed a motion. Am I wrong about that?
I did not file a motion. It was my intention to do so. Unfortunately, I was unable to accomplish that. I would still like the opportunity to do that. That was one of the things I wanted to bring up.
All right, well, we'll address that in a minute. Don't let me forget about it, but I don't have anything in front of me, so hard for me to do that, decide what to do yet. So Ms. Hansel, have you received copies of the motions by Mom's counsel?
I have.
All right. Ms. Cannon, why don't you go ahead and argue your motions?
Yes, Your Honor, before I get to the motions, I wanted to point out to the court that on March 31st, you issued a scheduling order in this matter, and that scheduling order provided certain requirements for all parties, including that 14 days before trial, everyone was to file a witness and an exhibit list. I have not received a witness or exhibit list from anyone. And I mean, the other motions that I have, these were written before the fact that the date that the witness and exhibit lists were due. Before I get into my next motions, I'm going to make a request of this court that I can say that I've never ever had to make before in my life and in my career, I should say. And that request, Your Honor, is for you to dismiss this petition with prejudice. Your Honor, we have been waiting this trial. The children were removed in October of 2025. The basis of the removal are allegations that a maternal grandmother used physical discipline on the children in May of 2025. I'm not going to sit here and talk about all the facts, but I wanted to be very clear with you that that was the impetus for this investigation, and that is the core of what the government has to bring about in the trial. There's some other ancillary things. Every time I've been before you, you have been the most prepared person in the courtroom when it came to my motions. I know you read everything. It is not by accident that they didn't file a witness or exhibit list. I will get into these other issues that they didn't do. They've done nothing to prepare for trial. And I've done everything, including trying to do their job for them. But at a certain point, Judge Hesselink, I'm the respondent's attorney. I'm not the person here required to babysit or tell other lawyers what they're required to do. So
hang on.
Yeah.
Hang on. So the basis of your motion to throw out the petition is what?
3.922D is the discovery rule in this matter, 3.922. And when you go to 3.922D, and this is going to lubricate for my other motions, Judge, it says that failure to comply, first of all, 3.922 does not require Any kind of motions for discovery doesn't even require a court order. You issued a court order on March 31st, 2026, saying everyone had to file a witness and exhibit list. Now, if you go down to the bottom of 3.922, it also says that failure to comply with that rule is subject to the rules in MCR 2.313. And if you go to 2.313 B2, it tells the court that if a party or an officer, director, or managing agent of a party or person fails to obey an order to provide permit discovery, the court in which the action is pending may, not shall, but may, an order refusing the disobedient party to support or oppose the designated claims or defenses, prohibiting the party from introducing designated matters into evidence, striking pleadings or parts of pleadings, staying further proceedings until the order is due, and finally, Your Honor, dismissing the action or proceeding or a part of it, or rendering a judgment by default against the disobedient party. The reason that I think the witness list and exhibit list to me are the most basic thing an attorney has to do, whether it's a jury or a judge. It possibly could take an attorney a half an hour. I'm defending this case. And I think the most important thing I want to tell you, I'm not here to put down other lawyers. I take no joy in that. The real issue is that if anybody here today thought these children were at any kind of risk of harm with the mother, if anyone was worried that the mother was going to hurt these children, they would have made sure to file that witness and exhibit list. Never mind, they didn't respond to my motions. Never mind, on last Friday, I get an email for an admin saying, can we get an adjournment because Mr. Vernon wants time to review. He just got on the case. These cases involve 14th Amendment and fundamental liberty issues. So I'm not going to keep talking, Your Honor. I think it's very serious. Not on this issue, I'm not going to keep talking. I promise on the other issues, I will keep
I've
talking.
never heard a lawyer say that.
Yeah.
Okay.
No, not on this issue. I'm going to leave it where it is. I'm dismayed. I'm very dismayed. And I think the court should be dismayed. It's your order. And how am I supposed to prepare for this trial? How is my client supposed to defend this situation? We don't even know who they're calling. And they're going to ask you for an adjournment today. We do not agree to it. The children have been out of her care for 8 months. We were here in March. I was told that this was the soonest court date we could get for a jury trial. I do not understand why they think that this was okay unless they think the children are not at risk of harm. So that's my first thing. And then I'm sorry, I know, but I didn't know about the witness exhibit list when I wrote these other motions.
I understand.
Okay.
Mr. Vernon, your response?
With regards to the witness and exhibit list, I would acknowledge that we did not file one. It was my understanding that Mr. Sommerfeld had done that prior to my taking over the case. Clearly that was missed. We would like to, the opportunity to file a witness and exhibit list. The reality is, from my perspective, is consistent with this motion and the witness and exhibit list filed by Ms. Cannon on behalf of the respondent mom. There's a great deal of information that I don't have. If she wants to file or she wants to admit evidence related to the divorce case file, the PPO case file, the other PPO case file, there's a grievance filed against Ms. Sullivan. I haven't seen any of those documents. I don't have any idea what she's referring to with that. If it's her intention to admit some of those things, I will need the opportunity to review that full case file from the court, and I obviously would need some additional time to do that. It's not something that appears that Mr. Sommerfeld was able to get to, and if he did, he didn't leave any notes in the file for me to review. So yeah, if the I understand that the court has set this for, I think, 3 or 4 days. I realized that that amount of time is hard to find on the court's docket. And again, I take responsibility for the fact that, you know, we did not do that. There's an awful lot here. I think that Ms. Cannon points to the crux of the matter, which it's a fairly straightforward matter. Did grandma hit the kid with a spoon, and did mom know about it? And did mom allow the grandma to be around the kid? I don't know why that's going to take 3 or 4 days. But if that's what the court set it for, then so be it. I wasn't part of that conversation. But if it's all these, I mean, if all of these people are here to testify to these things and all these exhibits intend to be admitted, you know, I am respectfully asking this court to grant me some time to accomplish that. At which point I'd be able to provide an appropriate and proper witness list to address all of those issues and concerns. I'm not in a position to do that at this moment.
How long have you been into the department's position that you're in now, Mr. Vernon?
I think my first case was in early June, maybe in May. I'd have to look at my calendar to see, but I can pull that up right now and see.
Okay.
Oh, you know what I can do is I can check my timesheets. Hold on 1 second. So it looks like that's a SCOTUS. So it looks like I appeared on May 28th was the first time. Actually, it would have been May 29th would have been the first time that I appeared.
All right. There is a summons in the court file dated April 9th, 2026, setting the circuit court trial for July 22nd, 23rd, and 24th. So it would have been preceding your being brought into the fold. And I recognize the amount of work that it takes to get caught up when you're coming into things cold. But it is not the respondent's fault for the old attorney leaving and the new one coming in. So I'm trying very hard to balance those issues and make sure that everybody gets fairness and is entitled to have their day in court and have the ability to be prepared for their day in court. Typically on discovery issues, I am loath to dismiss matters because I want everybody to have the ability to make their decisions made on the merits of the case as opposed to the technicalities of the procedural rules. So what I'm going to do is I'm going to contemplate that request, and I'm going to listen to the rest of your motions. When I get to the end of the motions, I'll make my decision on them, and then we'll circle back and I'll decide whether or not there's any prejudice or whether there's any ability to make interim orders that may satisfy or at least ameliorate some of the problems with you can go ahead and argue the rest of your motions.
Yes, Your Honor. One of my motions is entitled Respondent's Motion to Strike the Children's Statement from the Petition, and a motion in limine regarding the children's CAC statements, request for sanctions for failure to comply with 3.202 at 3.22 and other requests for relief. Your Honor, when I got on this case, I immediately in February, at the end of January of 2026, beginning of February of 2026, I emailed Mr. Sommerfeld and asked him that we do a protective order and that I be allowed to get the CAC videos to watch them, recognizing that my client might have a right to call an expert, recognize that I have the utmost requirement to be effective on her behalf. Mr. Sommerfeld sent me a response that was basically, he said that he didn't know, and I've attached all these emails. I'm not gonna go through each one painfully, but these are all attached to my motions if the court wanted to review them after this. He basically said, I don't know how to get those kind of DVDs because they're not in my custody. And if you need anything else, you need to go see Miss Sullivan. They're the people that are gonna get you your discovery. So I'm new to, I'm the new guy here, right? So I filed copious motions. Those are the motions I was talking about, and I brought them before you. And those motions were brought before you on March 31st of 2026. And you immediately recognized my right, I should say the respondent's right, to watch the CAC videos. And you instructed everyone to cooperate with entering a protective order and for the CAC statements to be tendered to me. Well, let me tell you what happened. I went through, I would say, 6 weeks of emailing. And not only did I email Mr. Sommerfeld, but I was emailing Ms. Hansel and I was emailing Mr. Blumberg. And just so you know, Your Honor, to date, no one responds to any of my emails. Who cares about my feelings? I'm a big girl. I know what I'm doing here. But the point of the matter is, no one ever responded to me about the protective order. And I'm just studying every week, week after week, Mr. Sommerfeld, I need these. And it got to the point at the end of May where I asked Mr. Sommerfeld, will you enter an order that does not include Mr. Blumberg's signature? Because Ms. Hansel had agreed to sign the protective order so that I could view the video. However, Mr. Blumberg had not agreed. And Mr. Sommerfeld's departing words to me were like, I'll reach out to Elliot again to see if he'll agree. Okay. I never, ever heard from Mr. Sommerfeld about that. I contacted Mr. Vernon on June 15th of 2026, because again, that's my job. I have to ask for these things when I'm not getting them. And I was trying to explain to Mr. Vernon, this is what's going on. I need these DVDs. Mr. Blumberg has not.
So the bottom line is you haven't seen the interviews at the CAC.
But it's also critical to point out to you that the effort to allow me to see them has not been there. And I believe that the department should be sanctioned. I believe that Mr. Blumberg, I'm very remiss, Mr. Blumberg should be required to explain to you why he didn't cooperate. Because remember, there's a divorce that is not done here. The parents are in an active divorce, okay? And it's not even, the judgment hasn't even been entered. So there's issues with custody, parenting time. Those are the things that also kind of loom in the background of this case. And so my request is that, oh, and by the way, Your Honor, at this point, they were required to file a motion 7 days ago, because if you look at 3.972 of the juvenile code, it says that if the parties want to introduce statements about children's statements at a CAC, that they really shouldn't, they can't file a motion no later than 7 days before trial. But actually, it also says that 21 days after the trial schedule, they're supposed to tender it, we're supposed to have it. But then it says the motion itself has to be filed 7 days before the trial. Here we are today. I've still yet to get a motion for the children's statements. And I would argue that your order in March 31st also said that all motions had to be heard today. So here's how I saw that. The latest, that 3.972 motion about the children's statement should have been heard is today. Because again, your March 31st order said, today's the date. that we do all our motions. There's no motion. So are they asking you today that they want more time so they can file a 3.972 motion when my client has, 4 kids under the age of 8 or 6 that she hasn't had in her custody for 8 months? So that's a part of it. So in my opinion, not only under 3.922 have they failed to comply with the court's order, but they failed to file a motion that would even admit the statements into the record. That basically you would have to have a hearing and determine whether or not the statements made by the children were reliable or not reliable. And, the statements, are such that they, they're innuendo in this petition. Judge, remember, these children in a preliminary hearing, they were removed from the mother based on these allegations, and they don't want to share it with me. And this motion here, it goes email by email. In over 20 years, I think there was only one other time in my career where I had to attach other lawyers' emails. I hate that. I have disdain for that way of practicing law. I really do. But when I call Mr. Vernon and he's sort of like, I'm going to be frank with you. The impression I got was like, you have motions to file them. So this is my second motion about those DVDs. So I am asking for sanctions against the department, reasonable attorney fees. They waived their right to admit the statement, so the statement should not be admitted. I'm asking that the petition be stricken of the statements by the children. And I'm also asking that any reference to the children, the CAC in the trial, if you so decide to grant them a trial next week, but any statements referencing the CAC, anything that happened at the CAC, anything about that CAC, not be allowed at the trial. And I'll tell you why, Judge, because now if you talk about other things about the CAC, now we're going to tell the jury what's a CAC. It's a place where people take kids to make statements. And right there, that's prejudicial to my client. I've never been on a case in which the counsel for the Department of Health and Human Services, and I'm going to brag a little bit. I was a caseworker when I was really, really young. Okay. The only person's job in here that I haven't done is yours, Your Honor. That's the only person. And I have no desire to do it, but because I think it's a really hard job, but I want to be, yeah. I've done all of their jobs. This not turning this DVD over. Okay, I'm done. Yeah, I'm not.
Thank you.
I have one more motion.
I'm not, I'll let you get to it, but I'm not the jury.
I understand. Yeah, I apologize.
No, you're doing fine. Thank you. Mr. Vernon, as to the interviews of the kids at the CAC, is that going to be evidence that you intend to use at trial?
It is my understanding that was what so I guess the short answer is yes, we intended to use that. Consistent with
her arguments then.
So to suggest that Mr. Sommerfeld and I didn't cooperate with getting the protective order in place seems a little disingenuous based on her own motion that Mr. Sommerfeld actually made edits to her motion or to her stipulated order and then submitted it to all the other attorneys essentially to assist her in getting that done. So I don't know how she can claim that the department somehow interfered with that. We clearly did.
My question isn't so much who's at fault. My question is, did she get the CAC interview of the kids?
We don't have it. It's not something she can get from us.
I don't care whether you have it or not. The order was that she get it. Do you have any reason to believe that she's got it?
I have no reason to believe that she has it. I have no reason to believe that the department has it. I have no reason to believe that we interfered with the accomplishing of a protective order so that the court could distribute that from the parties that do have it to the parties that want it.
How are you going to use it at trial, or how are you going to use the testimony of the kids at trial if you haven't complied with the court's order so that the other side has a copy of it?
My expectation was that the protective order would be signed consistent with Mr. Sommerfeld's efforts, and that all the parties would get it, and then we'd all have it, and we'd be able to use it.
Knowing now that that's not the case, how do you expect to use that evidence at trial?
I mean, if the court rules that we can't because of that, then, I have other witnesses I can call to identify some of those issues. But I think it's best if it comes from the kids. As far as, the evidentiary issues, we could, again, if the court would allow the adjournment we have requested, we could assist with getting that. Again, the CAC interviewers are on Ms. Cannon's witness and exhibit list. So she's at least aware of who they are. We could have conversations with them to accomplish those things.
What is your understanding of why the document allowing the discovery of the interview was not signed by all parties?
I have no knowledge as to why it was not. I understand from the notes that I have from Mr. Sommerfeld that he assisted with sending that out to the other attorneys. He made an edit because I think there was something missing with regards to, I think it was Mr. Blumberg's name was missing. I think there was maybe one other correction that he made. And then he sent it back to Ms. Cannon as well as to the other attorneys for signature. It is unclear to me as to why nobody followed up with that.
Can I address that, Judge?
Hang on just a minute, Mr. Blumberg. I'll get to you in just a second. Thank you. Ms. Hansel, did you see the proposed order that would allow the CAC interview to be sent to Mother's counsel?
Yes, Your Honor. I was out of the office at that time. However, I did give permission to counsel to sign my name to it. So yes, I'm aware of it, and I believed that it had been signed.
All right, Mr. Blumberg, your thoughts on that matter?
Judge, one of the few things I've agreed with Ms. Cannon about is the lack of clarity as to the position of the non-respondent's attorney. To this day, I'm not 100% sure whether I can call witnesses, whether I even have the right to participate in terms of examination of Ms. Lee. I think she has some questions about that as well, as she raises in her most recent motion. So my failure to sign the protective order, one, I never got a single phone call from Ms. Cannon asking why I haven't signed it. Am I going to sign it? Do I have the authority to sign it? It's never been clear to me what my role as the attorney for the non-respondent father is in this case. I don't know if that's an excuse. It's certainly my explanation.
So are you telling me that you did or that you didn't see it and sign it?
Eventually I saw it. I did not sign it because I didn't know if I had the authority to sign it or what weight, if any, my participation was going to allow me to sign it.
Ms. Cannon, more ammunition, please,
More ammunition for this motion?
for any motion that you have.
Oh, okay, yes, Your Honor. So the other motion that I filed, I tried to identify some issues that I thought I didn't want to have to deal with on the date of trial or in front of a jury. I think it's always best to try to do a motion in limine, if possible, if you can identify those issues. So there was another piece of discovery that was not tendered, and it was a critical piece of discovery, Your Honor. And that's that in the petition, in an effort to remove for support of removing the children, Ms. Sullivan, the caseworker, wrote that she had viewed text messages and pictures that had injuries of the children as a result of the spoon incident, and also included text messages from the mother. Now, she was shown, we were able to determine that she was shown these items by the police by the father, okay? That the father showed her those items. When I asked for those items, I was told that I would have to get them from the father. And I'm just gonna say this to Your Honor, that father has no standing to file a petition to remove children. This is not the father's petition. This is the petition signed by the Department of Health and Human Services. I'm gonna like underline this, like, can we imagine the day of prosecutions where complainants, right? If this was criminal, where a complainant goes and tells a prosecutor, look, I have all this stuff, you should press charges. And then the prosecutor presses charges. And then the prosecutor tells the defense attorney, hey, you can't get that from me. You got to go to the non-respondent parent who has no obligation to you to get this stuff. And I use that as an example, Judge, because in these cases, one of the most exciting things about it for me as an attorney is that this whole concept of liberty interest, it's a real thing for me. I feel it in my bones, and I feel it on this case. You can't just start making allegations and telling.
Let me just stop you for there.
Yeah.
Just a minute. Let me say this. I'm one of the judges that really doesn't care what an attorney feels.
I'll let it go.
So, and
Okay.
I'm not
hurt.
downgrading. I'm just saying, tell me
Okay.
what the law is,
So
tell me what the facts are, and let me make my own decision. I really don't have.
I'm going to let that go.
I don't,
Okay.
it doesn't matter. So
3.922 requires them to turn over discovery to me. Their petition identifies page 5, section 2 of their petition. Ms. Sullivan claims she observed text messages and pictures of the children as a result of this alleged or this spoon incident. However, the department failed to tender the pictures and the text, claiming that the evidence would need to be provided by the father's attorney. Okay. Now, so because of their failure to tender that evidence, I'm requesting the court require them to strike in the petition any reference to the pictures, to the text message, and limit them from bringing up those pieces of evidence in the trial. Complete. And in the petition, that would be page 5, paragraph 2, and it would be page 5, paragraph 2, I through 3. Also, Your Honor, one of the reasons why I would need these text messages and pictures is because there's always issues related to authentication. You know, we live in a day and age where people can distort things. And so one of the reasons a good attorney needs to review the documents before trial is to make sure that they can see what the document is, so they can investigate the document. Complete on that issue.
thank you. Mr. Vernon, is it your intention to use testimony and or the screenshots and or the text messages referenced in paragraph 2 of the petition, subparagraphs I, II, and III?
Certainly, we would be looking to introduce at least testimony regarding those things. Certainly, we would call the father, the non-respondent father, Mr. Lee, as a witness, and he could testify as to those concerns. The reality of the situation is that we don't have those documents and those pictures. My clients aren't allowed to possess them. A third-party subpoena by Ms. Cannon could have accomplished that just as easily as our having done it. So for her to blame us seems a little, again, disingenuous, when she could have done the exact same thing that we could have done to get those from Mr. Blumberg's client. I can call Mr. Lee as a witness, and he can testify to that. I don't think what he saw in a photograph is hearsay, so it's not a statement. So again, we can call those witnesses and we can have that conversation.
Tell me why the department can't have pictures of abuse and neglect of children.
Because the photographs show a naked children and they can't have those.
You're out of your mind.
That's my understanding, Your Honor.
Ms. Sullivan, tell me I'm out of my mind.
You're not out of your mind. However, DHHS policy states that the department cannot possess any photos of buttocks, breasts, or genitalia, and the photos are of buttocks, so we cannot possess those photos.
How are you supposed to do a case that has abuse and neglect of a child on the buttocks?
That is a great question. But that I have to abide by policy, so I was able to view those photos, and then I had to delete them because I could not have them in my possession. So
How am I supposed to let? I am absolutely flabbergasted that you would not be able to have evidence that you're going to talk about in your case and that you would not be able to send it to the opposite side. What in the world are we doing here?
I cannot argue with you at all whatsoever. I would love to be able to have those photos and to distribute them, but per policy, I would lose my job if I were to have them in my possession.
I'm not disagreeing with you, but DHH's policy just earned them a dismissal of this case. That's absolutely ridiculous. They have an absolute right to see, hear, and evaluate the potential evidence in this case. What they're asking for is basic 101 prosecution of a case. And for the department to say, we don't have it, sorry, go get it from someplace else, and then want to come into court and use it. I'm not mad at you, Ms. Sullivan. I am absolutely, don't take this the wrong way. Mr. Vernon, I am not upset with that, but this is what's going to happen in this case. You're going to prepare a motion that says, for the reasons argued in your 1, 2, and 3, your motions today, for failure to provide discovery that according to the court rule that you cited to me, the case is dismissed. Mr. Vernon and Ms. Sullivan, please take this up the flagpole and tell the department what their policy has resulted in. I would love to have a conversation with them about this, because every time this happens again, I'm going to make the same ruling. They have the defense, the respondent parents have an absolute right to see, hear, and evaluate the evidence that is being brought forward to them. And it is outrageous that they would not be provided with that, especially where it was court ordered to begin with, at least on the video stuff. But specifically, these pictures would be absolutely, this is the 3rd time now that I've listened, and I agree with counsel. This is just absolutely ridiculous. So that's the order. We're not having a trial come next week because the case is dismissed. Thank you very much. That's all.
Your Honor, can we clarify whether the request for this to be with or without prejudice?
I requested it be with prejudice on his petition.
The number of violations in this case show to me that it is with prejudice. I don't make that decision lightly, but no, I'm not going where you guys are at. This is not acceptable. So it is with prejudice.
Thank you, Your Honor.
Thank you. Have a good day.
Thank you for the clarification.
I'll prepare the order.
Thank you.
We are free to go.